May it please the court, Jonathan Sharp, from Apple's Office for Ferguson West, and do it on behalf of the Helen plaintiffs. I'd like to reserve 5 minutes. I appreciate the opportunity to be here this morning. For me, the most important thing is to answer any questions you have. You've got a little briefing on the subject, and it's a subject about a single affirmative defense that was decided at the outset of the litigation.
You mind if I just get to it?
Sure.
Okay, you obviously had a first lawsuit.
Yes.
That got settled, and it had to do with, fees on, what was it, overdraft fees and things like that. And you had a settlement agreement. And the settlement agreement, the language basically said claims that result from, arise out of, or based upon, or relate to the conduct of mission duties matters during the past period that were or could have been alleged and action related to the claims and defenses set out in the complaint and answer. Why doesn't this language cover the subsequent suit where that was brought to challenge the fees that were overdraft fees on debit cards? I mean, were brought or could have been brought. I mean, I know it's supposed to be a limited release, but it was written like a general release.
Well, both parties agree that it's a limited release. Right?
Yeah.
And I've read a bunch of these, like a lot of this overdraft fee and NSF litigation here in Florida and around the country. Certainly I'm critical of my language looking at it because of what happened with the circuit court's order in this case. But the end language that you just read, the last phrase relating to the claims and defenses set out in the complaint answer are an important qualifier. And that qualifier means that the case, which was only about NSF fees and overdraft fees on ACH transactions and check transactions, that created the limits of what the release was about. So we finished a case, we settled a case for a fund of money for a group of account holders that had ACH transactions or check transactions reprocessed by the bank, or the credit union in this case, multiple times. And they charged a second or a third fee. And we alleged in the first case, in the Baptiste complaint, and we survived a motion to dismiss and then settled that case, that the credit union was prohibited from charging more than one fee because of the language in the contract. We finished the case. Ms. Snyder approaches us and says, hey, I have this overdraft fee. And the overdraft fee that we see is on a debit card transaction. And we point this out in our briefing, but we emphasize for you, Judge Morris, and your honors, that there can never be an NSF fee on a debit card transaction. Once the debit card transaction is authorized, it has to be paid. There's a ramification of an overdraft fee. We say in this particular case that the overdraft fee was not able to be assessed because the account agreement had language that said once the credit union authorized the transaction against a positive available balance, the language in the agreement said you can't charge a fee, even if the balance at the time it settles is.
Let's go back to the release language.
Yes.
And you focused on some very important language, and I appreciate that. But what about the language that said claims that were or could have been alleged?
I still believe that it could have been alleged. And if we had just said could have been alleged, perhaps it would be more ambiguous as to what we were doing. But when we said could have been alleged, and then we frame it based upon what the complaint and the answer were about, which were only ever about ACH transactions, check transactions, and whether these multiple NSF or multiple NSF or even a single NSF followed by an overdraft fee could be charged under different contract language in the agreement in the fee schedule. We did enough. And I think purposely, both parties, there's different counsel representing the defendant in this case and representing the defendant in the last case. But when we went about drafting this thing, we looked at what are we suing about? And we only sued about this one theory of liability with regard to the ACHs and checks. So that's what I would emphasize to you with regard to
Well,
that issue.
let's talk about the Baptiste complaint,
Yes,
because I think that goes to the breadth or narrowness of the release. Paragraph 1 of the Baptiste complaint, which is a class action complaint, GT's routine practice of charging 2 or more fees to multiple fees, including overdraft fees and non-sufficient fund fees on a single item, breaches contractual promises and the covenant of good faith, then talks about the account documents that govern. Paragraph 4, plaintiff disputes GTE unlawfully maximizing its already profitable account fees with deceptive practices that violate its contract, specifically assesses multiple fees on a single automated clearinghouse transaction or check, and then it goes forward, only a single fee will be charged for overdrafts, including NSF and overdraft created by check, in-person withdrawals, ATM withdrawals, or electronic means. So the allegations in the Baptiste complaint are broader. I understand what the cause of action is based on, but the allegations are broader than just here's how it applies, but only as to ACH transactions. And so the release language, which says could have been brought, seems to me that based on the allegations of paragraphs 1 through 7 and beyond, the same claim that you presented in Snyder's case could have been brought in the Baptiste case.
so recognizing that you quoted those paragraphs, I don't see it, my client doesn't see it as though in the Baptiste complaint, it was as broad, because we were only pleading about transactions that did in fact overdraft the account, and therefore, if you're going to return the transaction, you may charge an SF fee. If you're going to pay that transaction, an ACH transaction, you're going to charge an overdraft fee. But the complaint, and there are times when you could bring these two claims for different people because they may not all have the same claim.
But it's a class action.
It is a class action.
And your client, in this case, either could have participated or did participate in that class action.
Yes.
And so are you saying there was no ability for her to bring this NSF claim in the Baptiste case?
Well, she's not the plaintiff in the Baptiste. She's an absent class member. And one of the things that I wanted to emphasize in the court,
But she could have opted out of the class.
she could have opted out of the class if she had thought that I have some other fee and maybe I'm unhappy
But
with
at
it.
the time this class was formed, she would have known about all the fees that she was imposed, that were imposed on her, didn't she? Because they all happened as part of one transaction. Well, we'll call it 2 transactions, but one series of events led to both NSF fees.
In the dozen years that I've been doing this litigation, dozen plus years, it becomes clear that account holders compared to whether it's a credit union or a bank, they don't really have a clear understanding of what is going on.
But that's why they have law firms.
They have law firms. And so she was notified, and I asked the court if you want to talk about, if I had the court to consider that, what was she notified about? She gets a postcard or an email in the mail that says, hey, we believe you're part of this class. You can stay in the class or you can opt out of the class. And she's notified if she goes and looks at the settlement agreement, and we get focus to paragraphs that surround, and the case law, Moxley and Alderman dictate that you need to look at the purpose, the terms of which the language of the release is stated, and the subject matter which it applies, and says, let's also look at other paragraphs besides the paragraph 91 that Judge Morris started asking me about. And if you look at the focus of what she would have seen from reading paragraph 1 of the describing what the claim is, paragraph 27, what the multiple fees are, and confirming that that's only on ACH transactions and check transactions, not if she thought the credit union charged her an overdraft fee on a debit card transaction. It's not instructing her that she's at risk of releasing that claim. And the settlement class definition that incorporates the multiple fees definition, which is very specific to cabin the case there. So when you read all of those things together, as my client would request that you do, and the limited release that the parties have agreed to means it's only about the multiple fees issue. It's not about whether there is some other way in which the bank, the credit union violated its contract with regard to different contract language, different types of transactions, the different practice that is at issue that we've alleged is a breach of the contract. There's a case that we cited to you in a notice of supplemental authority. That case is called Tim versus LGE Credit. In that particular case, and I remember the case because we used it around the country because it denied a motion to dismiss. And it denied a motion to dismiss about one type of overdraft fee claim a number of years ago. The case ultimately settles. And in June of this year, Judge Thrash of the Northern District of Georgia was asked to enforce the injunction that he entered as part of the release language that was included in the settlement agreement. And a new lawsuit was filed. And this time, instead of suing for an overdraft fee that was caused by the a determination as to whether you're supposed to use the available balance in the account or the ledger balance in the account. That was the first Tim's case. The new lawsuit gets filed after that settlement is completed. And it's for this same theory of liability that we've alleged for this authorized positive settled negative transaction. And in a particular case, there was some similar language. The court said it was not going to impose an injunction to prevent that second action, the state court action, from going forward under the All Writs Act, because it did not arise out of or sufficiently relate to the settled claim. And quote, the mechanism by which Pincott alleges the defendant improperly overdrafted his account in December of 2018 also differs from what plaintiff alleged in the present case. That's page 8 of the order. Judge Thrash,
wasn't there a gap of years?
there was a different time period.
In this case, it was basically one series or set of transactions.
There is an overlap in this case, at least in the example transaction that we use for Ms. Snyder. We don't necessarily have all of the aspects and all of the information that the bank has. This APPSN claim is more complicated because you need to go look into you can't necessarily see this from the account statements. We believe we play a good faith basis every time we bring these claims, but you have to literally pull the data from the bank or the credit union in this case, and look at the order in which the transactions were authorized, because they're not only depicted that way on the account statements to figure out was there an available balance, a positive available balance.
But in terms of the Baptiste case and the discovery that would have been permitted in the Baptiste case, a lawyer who has a client who incurred multiple overdraft fees because of the alleged misconduct, they would have been able to find that out, right?
They
got a discovery saying you have balanced these transactions and they're all interrelated, and you wrongfully did this transaction resulting in multiple NSF charges. That would be subject to discovery if they're related.
And if we were talking about Ms. And I still don't think that the release would have been broad enough, but if we were talking about Ms. Baptiste coming back around and filing a second class action against GTE for this other conduct, perhaps there would be something to think about, even though I think the limited release doesn't cover it. But in this particular case, you're saying that the concept that you're presenting is that the absent class member who gets this notice, as I explained, is telling them only about these ACH transactions and check transactions. And you're suggesting that she would have to decide if she doesn't opt out, even if she thinks that the bank, the credit union has harmed her in some other way, she doesn't opt out. She's stuck with what is a limited release in here. And I think it's an unreasonable burden to place on an absent class
And they're
member.
like the debit card times into the same check.
It does. Yes, for sure it does. We've argued, and you hear this, and I heard you say, I think in the last argument, just about whether, no one's arguing whether it's ambiguous. So we certainly took the primary position, litigants often do, when they read something, they say it's unambiguously a limited release that doesn't bar this claim. From a summary judgment perspective, the burden being on the defendant to assert the affirmative defense. If there's two reasonable interpretations of this language because of the extra limiting phrase relating to the claims and defenses set out in the complaint. So those would be the claims that could have been brought as to what was sued on in the complaint, which Judge Silverman, I believe, is a narrower thing than what you suggested by your question to me earlier. Then,
Mr. Stressel, let me just let you know your rebuttal time. You can continue where
Yes.
reserved.
okay. And so when we think that, when we look at all of that, then if there's an ambiguity and both sides have offered a reasonable interpretation of the contract, then summary judgment should not have been granted. Perhaps an opportunity for the evidence to come in, something of that sort would allow the parties to further litigate the issue and get to the merits of the case. And claim splitting were the other two defenses. Judge Moe, she did not rule on those defenses. We've argued in the briefing why we believe those defenses don't apply. I'm happy to answer any questions you have under the Tipsy Coachman doctrine. It's our position that it would be premature for this court to rule on those, but ultimately, from the elements of the cause of action, the elements of those defenses are not met by the defense. So
Very good.
Report Michael Hahn on behalf of the TTE Federal Credit Union.
Can I ask you a question right off the bat?
Sure.
If Judge Moe didn't rule on the claim splitting issue or the res judicata issue, are those issues even in play here?
I believe that they are.
Well, we're an error correcting court, and if she didn't rule, she didn't make a mistake, so there's nothing for us to fix.
Well, she didn't rule with specifically with respect to those doctrines. However, she did find that. Let me find my notes on the matter here. The Snyder claims that the court didn't reach the factual findings on those defenses. The court did. The court held that the release was sufficient broad to cover the multi-NSF and APSN claims. So that finding, I believe, meets the identity of action requirement for res judicata in respect to the settlement agreement and a common set of factual parties for claims.
Who was the drafter of this settlement agreement?
I believe that the settlement agreement indicates that both plaintiffs.
Yeah,
counsel, and
That's
defense.
what I thought. I would yes.
Or does that be-
Yeah, that's not helpful anymore. Everybody does that now, so we can't construe it against a drafter because no one will say, I did it.
Right, and since we weren't involved in that particular litigation, we don't know to what extent the credit union participated, whereas counsel did. But the Snyder clearly released claims in place because the subject matter of both of the suits is the fee practices of GTE. All the fees in these cases are overdraft fees, in the sense that members incur fees when they don't have enough funds in their accounts to cover the transaction. And while there are differences in how the APSN and NSF fees are triggered, fees are ultimately due to lack of sufficient available funds in the account. And they're assessed when a merchant presents some transaction for payment. But there's insufficient funds to cover the transaction. It's just a question of how you get there. Now, we focus in our brief on paragraph 91. I think 93 is also important, but counsel indicated that this limiting language at the end of paragraph 91 relating to the claims and defenses set out in the complaint and action sort of take away what's given at the beginning of that paragraph. The beginning says any and all liabilities, rights, claims, actions, causes of action, infraction, whether known or unknown, existing or potential, based on contract, tort, law, or any other theory, forgetting anything out of this is that this part of it is extremely broad. That result from or rise out of are based on or related to the conduct, omission, duties, or matters. That's very, very broad language.
But everyone agrees, I believe, that this was a limited release, right?
It was a limited result.
So if that language is as broad as you suggest, and some of the questions I asked opposing counsel, you can tell I have some issues with that too. If it's a limited release, then what was it limited to?
It was limited to transactions that result in these overdraft banking fees.
Except for it ties it specifically to the complaint, the answer, and affirmative defense.
Certainly, certainly, and it did not cover other relationships that the account member may have with the bank. And there are certainly plenty of other relationships with respect to checking accounts and debit cards and overdraft fees and other fees. So it was meant to be narrow. But the question here is where does that narrowness begin and end, and where are the edges to it? And I would submit to the court that after looking at that first paragraph, and there's a question in your mind, I think what you need to do is look at paragraph 93.
Well, is it ambiguous then?
I don't think that it's ambiguous. And if there is any ambiguity to it, I think that paragraph 93 corrects or fixes that. Because paragraph 93 says that any settlement class member may hereafter discover facts other than or different from those that she or he knows or believes to be true. So different facts distinguishes APSN claims from the overdraft fees, that the multi-NSF fees in the Baptiste case. And they release each of those individuals expressly agrees that they have automatically and irrevocably waived any known or unknown, suspected or unsuspected, asserted or unasserted claims with respect to all of the matters described in or subsumed herein. This paragraph expands again to the extent that paragraph 91 contracts it. This expands it to claims that these individuals know. Now, I want to note that you mentioned earlier about the timing of these and whether the Snyder could have brought her claims. Baptiste was filed in March of 2020, and the Snyder's complaint references a, for example, transaction from May 2 of 2020. The settlement agreement for Baptiste wasn't approved until February 2021, and final approval wasn't until July. So unless I'm missing something, all class members, when they're participating, they're bound by the settlement agreement, whether they read it or they didn't read it, whether they got a postcard in the mail or whatever, they're bound by it if they don't opt out. So I think any idea that because the fact that Ms. Baptiste knew that she had an APSN transaction, she certainly could have brought it in this suit, particularly with counsel that she was represented by who had practiced in this area for so long. Ms. Snyder knew that she had an APSN claim, and the claim related to the credit union's fee practices.
What kinds of fee practices and the specific account that was covered, at least explicitly covered by the Baptiste case.
Yes. But she waited until her check cleared and then she sued. Consumers aren't the only ones that are subject to predatory practices. Sometimes it's plaintiffs who wait and then file another lawsuit. Credit unions are not banks. Credit unions are cooperatives. They're nonprofits. When a plaintiff sues in a class action against a credit union, they're taking money from the other credit union members that have a.
That's a double-edged sword, because if the credit union is engaging in misconduct, then it's earning money that it shouldn't be earning, right?
Certainly. The credit union was not engaging in bad conduct. There's something protecting their credit union members, disclosing to them what fees will be imposed, when they'll be imposed on, because just like lawsuits, credit union members who are continually overdrawing on their accounts are also costing the other credit union members. So in credit unions view, and in light of strong policy in Florida favoring settlement and finality of settlement agreements, we believe that the judgment of the circuit court should be affirmed.
And as I read the record, I don't recall this specifically. Is there anything that explains this particular practice and why it is valid? I know we didn't get to the merit, the trial court didn't get the merits, but was that covered under that fee suit? I'm assuming the answer is no, because this kind of transaction wasn't explicitly dealt with that fee suit.
It wasn't particularly addressed in the Baptiste suit, to my recollection.
It does seem to be problematic. And this obviously doesn't turn any decision on the case because we're not here on the merits of that, but it does seem problematic that there's a hold on a debit charge. And then it's released briefly, causing the debit charge to fail. Isn't that the reason why there's a hold?
Well, this is an interesting subject, and the internet and the digitization of, the modern world is really trying to catch up with. If you go into a restaurant and you charge $100, you get billed for $100. You give them your credit card, they go and they check and they see what's authorized. They don't actually charge your credit card. That is not done until it's in cash and later on.
Right, but with debit, some of this is just sort of common sense from what has happened for years. But typically, when there's a debit transaction, there's more than enough that is held by the bank or the credit union to cover that. And isn't the retail outlet relying on that to get paid?
But it's not held.
It's segregated.
It's not segregated. It's not set off.
So when I get these notices that say, if you use your debit card, you may experience a hold in excess of the amount, that's not true.
It is not true in the sense that they are taking the money and putting it in a lockbox and setting it aside. If you have a credit limit or a limit on the amount of money that you're allowed to charge, what they're doing is they're authorizing the amount. And then
So you're representing
settled later.
banks and credit unions are representing to a retail outlet, you're covered. You're going to get paid because the money is there.
Well, they have to pay. Having to pay and having the money set aside are two different things. When an amount is authorized by a retailer, by a merchant, the credit union has to pay that amount.
When the credit union or a bank says this transaction can go through because there are funds there,
That's correct.
the retailer is going to get paid.
And that's authorized in a positive balance.
And then what happens, as I understand from this case, there is a release of those funds for whatever reason, a release of what I'll call a hold, even though I know you don't like that term, but the release of the hold, which ultimately means retailer is going to get paid, but now your customer is going to get an overdraft charge because this other transaction didn't go through.
Well, you have an intervening transaction. What happens here, or the amount that's authorized is $100 for your dinner, and then you add a $20 tip, but your balance in your account is only $110. So it's authorized on a positive balance and settled on a negative. That happens without the credit union setting this money aside or holding on to it in any sense.
But ultimately, that type of transaction has not been reached on the merits. The validity of that or the propriety of it has not been reached on the merits.
That's correct.
Okay.
Nothing further. Thank you.
Thank you very much.
That pick off a few main points in rebuttal. When Judge Peacock denied the motion to dismiss in Baptiste, she was being asked to look at language specific to this issue of whether multiple insufficient fund fees could be charged. That's all she interpreted. She found the contract was ambiguous. Realized the contract, either should be interpreted or it is ambiguous as it is a authorized positive settlement. It is a true hold on funds. I could talk to you about this. I've been doing this for years. I could talk to you.
Ultimately, we don't even reach that issue.
Correct. And it's my hope that I will get to reach that issue with Judge Mo in the case of the reverse and the remaining on behalf of the Judge Mo did not rule on the issues of res judicata and claim splitting. I believe the transcript will just.
So is there anything for us to do here?
I believe not. I mean, ultimately, I think that if you found a way to do it, you should find for the plaintiff that the elements are not met. It's not the same exact cause of action for the reasons that I explained to you in my initial arguments, with emphasis on Judge Silverman's questions. GTE has a hindsight-driven look at this release that both sides drafted. The plaintiff side, my firm included, and GTE's predecessor counsel.
But let me ask, because paragraph 94, nobody's really talked about in the
Yes.
release. That seems to be the effort to keep this as a limited release rather than a general release.
So our briefing certainly does that, and it's leaving out things, other types of relationships. If, let's assume somebody didn't pay a fee, sometimes that happens, especially in an overdraft situation. The account overdraft fees get charged, there's no subsequent deposit. So in this particular case, if Ms. Snyder had gotten sued, maybe they sent it to collection, something of that nature, and she hadn't paid a fee, then she would reserve her rights with regard to what was not released in the case. Even paragraph 93 that was discussed by Mr. Hahn, with the panel here today, includes language. It says all of their claims in the action. And if you agree with me, I know you gave me some pushback, Judge, initially, but if you agree with the plaintiff that the complaint in Baptiste was not so broadly drafted, then it fits in that this limited release doesn't prevent Snyder from the claim here. The GTE wanted to prevent all overdraft fees of any type to have been released. Different language should have been used. I think we suggested other types of language that could have been used in our reply brief. Judge Marsh, you asked Mr. Hahn about the limited nature of the release. If you take the limited nature of the release and you say it's not covering every account fee that could have ever been charged, certainly not every insufficient funds fee ever been charged, and then you add to it, as Moxley and Alderman require, paragraph 1, paragraph 27, and paragraph 46 of the settlement agreement, which give the focus on what a multiple fee claim is, all the ACH transactions and checks, then we believe it's clear that it's limited to exclude what's being pled in the Snyder case. And if it's ambiguous, then the Montana case and the San Giovanni case from this court would say there's a question of fact. The summary judgment was improperly granted even before the motion to dismiss was decided in this case. And with that, I would ask that the court reverse and remand, determining that the defendant did not meet its burden to prove the release offense.
Very good. Thank you both. We've had a series of interesting and different facts today.
Yeah, it's very interesting.
This has been that as well.
Thank you. You all did a great job.
Thank you.
We are concerned.
All rise.
Hopefully my son will be sitting in that.
Thank you.
I'm gonna start creaking when I stand up. Thank you, travel safely.